So this is beginning of chapter 23, sales contracts and warranties. So we're going to be looking at the general topic of warranties and whether they're intended or not, and how they operate. So this is a kind of an interesting case for a couple reasons. One is this is a general business law course. So as you remember in the earlier part of the course, we talked about tort law. So this case fits almost better under tort law, but we'll talk a little bit about the warranties also. So some of you may be familiar with this topic. About 10 years ago or so, New York City in particular suffered the hotels there suffered a bedbug invasion, and it was a very horrible thing. Bedbugs are kind of similar to the COVID-19 virus, are very easy to transmit. In fact, basically, if you ever get into a hotel and you discover there are bed bugs, the very best thing you can do, this sounds horrible, is to leave all of your stuff in the room. Don't leave the room. Go to another room, take off all your clothes, put a new set of clothes that you go buy from the store or order from the store to be delivered to you, and start over, because bed bugs are very pernicious and they're very hard to get rid of. Now, in the last 10 years, because of the severity of the problem, they have developed some insecticides that work pretty well, and they've also developed a technique for sanitizing a room, where it turns out bed bugs are kind of fragile creatures, even though they're easy to spread. And so they can heat the room that's infected with the bed bugs up to a temperature, I think it's around 140 degrees, leave it at that temperature for an hour or two, and it literally kills the bed bugs. They can't survive at that particular heat. But in any event, most of us, if we were not totally drunk or drugged out, if we were bitten while we were in bed at night by some bed bugs, we would probably jump up out of the bed and call the hotel front desk and fuss and mourn. So I find it somewhat odd that someone could suffer 500 bed bug bites. That does not sound realistic or possible. And the suit was for $20 million, which is a rather ludicrous number in light of the overall circumstances. But what the warranty that's involved here is the warranty of habitability. And we touched on this actually in the real estate chapters, which is if you're a landlord and you're renting a place, or you're a hotelier and you're renting a hotel room, you do need to rent a room that is habitable, that you can live in. And generally speaking, bed bugs are primarily not on the list of things that make a room inhabitable or uninhabitable, but certainly in this case that would be true, and businesses should not be renting hotel rooms that have a bed bug infestation. So anyway, kind of an interesting situation. Now, this goes back to our basics of contract law. We talked about the fact that an express warranty or an express contract, parallel to that, is something that is clearly been undertaken. So in the case of an express warranty, the buyer has been made an express warranty by the seller. A good example of this would be if you're looking at a used car lot, and you're a starving college student, so you want a low-cost car that gets very good gas mileage. So you say to the person running the used car lot, this is what I need. The salesperson takes you to a particular car and said, this car gets 30 miles a gallon. It's one of the cheapest cars on the lot. This is what you need. You then take the car out, and unfortunately, you discover that the car gets horrible gas mileage because it's in very poor condition, maybe high mileage, and it's got some other mechanical problems. But that would be a violation of the express warranty by the person running the used car lot, saying that the car would get good gas mileage. And oftentimes, of course, they'll also say the car is in good condition, although they may say that a used car is being sold as is. We're going to look at that separately in just a second. Now, there's no specific words required for a warranty or a guarantee, but it has to be clear that it's a statement of fact to the buyer that creates an express warranty. Now, obviously, a good consumer is going to want that warranty in writing. So a lot of used car lots may say the car's basically sold as is, but we're going to give you a special 5-day window within the first 300 miles driven or the first 5 days, whichever comes first. Then if you're unhappy with the car, you bring the car back, pay us a little handling fee, we'll take the car back. So that's an express warranty, but it's a limited express warranty. Now, watch out for statements of opinion. Boy, this is a really cherry car. This is a really cool car, stuff like that. That does not create a warranty. You need to look for things that represent more specific facts. So regarding the issue whether express warranty was created under the code, in seed brochures were an opinion or express warranty. I would lean towards the fact that if it's printed material from the manufacturer, that creates an express warranty, although I'd be looking for terms that say warranty or that make a specific representation. Now, one of the most interesting things is that I don't think this is a phrase that's used very much today, but it used to be that a sign of someone that was a bad business person or a moron would be you could sell that person the Brooklyn Bridge. Well, obviously the Brooklyn Bridge is not for sale. It's a fixture in the city of New York connecting Manhattan with Brooklyn. So it's you can't own it. So there's no warranty of title, so it can't be sold. So that's often used as an example of a foolish thing because somebody's selling you something that they do not own. Brooklyn Bridge. And so a rather obvious connection here is that we expect that when somebody is selling us something that they hold the warranty. So it is standard in business that if a merchant sells you something, they have the warranty of title. And that they're representing that they own it and they have the legal right to sell it. So let's always watch out for that. And now one other part of this is that's kind of interesting. If you buy from a merchant, and one of the most famous retailers in the world is Neiman Marcus. They were famous for a very, very elaborate, one-of-a-kind Christmas catalog. It was actually talked about on nighttime television and some news channels and things like that. Sadly, Neiman Marcus has gone into some tough times and went into bankruptcy. It was announced in the news this week that they were coming out of bankruptcy. They've done a very elaborate debt restructuring, which included $4 billion of debt either being forgiven or restructured. So it's a very significant restructuring, and we'll look some more at that in our chapter on bankruptcy. But in any event, you're a consumer, you're feeling wealthy one day, you go to Neiman Marcus and you buy yourself an item of clothing and you pay for it, of course. One of the things that cannot happen to you is that someone can't come to you and say, we don't really care if you gave money to Neiman Marcus or not. We're a creditor to Neiman Marcus. We want that item of clothing back. That will not happen under standard American rules of the law because the merchant seller warrants that the goods are free of rightful claims of any third person, which in our case means creditors to the business. So this is a standard piece of the way our retailing system operates, and it's very important. Now, keep in mind, this does not necessarily transfer to all circumstances, but it does in the retail sense. Now, there are two very important implied warranties that come with doing business in the United States. And the first one is the implied warranty merchantability. And this is very important. And so even though this is just a single slide with one definition on it, I do recommend if you're setting up a set of special slides for a final prep for your midterm exam or your final exam, you may want to import this slide to that set. So it's implied warranty merchantability. What this says is that, and it's quite clear here, the goods are reasonably fit for the general purposes for which they are sold. Now, I often use an example of a lawnmower. So you go and you need a lawnmower to cut your grass. And the thing meets merchantability because you turn it on, it cuts the grass. No big thrill. It's a merchantable item. Now, let's contrast that with our next slide, implied warranty of fitness for a particular purpose. Now, this is a much more specific warranty. In our circumstance, imagine that you need a lawnmower to cut the grass at the University of St. Thomas. And as you know, there's some large green spaces, particularly the one in the middle of the center of campus. And so you want a lawnmower specifically designed to cut that segment of lawn safely and quickly. So you go to a company that specializes in selling commercial lawnmowers. You describe the need that you have, and they say, oh, you need this particular model lawnmower for commercial applications. That is a warranty of fitness for a particular purpose because the vendor is telling you what specific lawnmower will do the job that you need to have done. And so it is a different situation than the implied warranty of merchantability. Now let's look at the significance of this. Is virtually any sale today includes an express disclaimer of these two warranties. Now, first of all, you cannot disclaim the warranty of title. If you're selling it, you sure better own it. So that's part number one. Number two is if you want to not be tied up with these two implied warranties, you must conspicuously disclaim them. So if you look at any of your warranties, any appliance or laptop, computer, cell phone, anything you've bought recently, and you look at the pamphlet that comes with it, there's usually a few pages on warranties, and it'll say, this is a limited warranty, read this, it limits your rights and so forth. That's a very typical headliner on this part of the instruction manual. It comes with things. And then it's going to say, we disclaim the implied warranty and the of merchantability fitness for a particular purpose. So again, take a look at that this evening when you get an opportunity. Note that the word merchantability must be there. Now it says it may be oral. That is a very dicey situation because that also invites someone to claim that they did not get the waiver warranty. So think about that. For most of us good business people, we're going to make sure that the disclaimers of these two implied warranties are definitely included in the warranty package. And so it's something that's very important. Now, at the bottom of the slide, I would have started a separate slide, is Magnuson-Moss Warranty Act. This, folks, is also known as the anti-lemon law, and it goes back to a particular period in the United States regarding environmental protection of all things. In 1970, President Richard Nixon signed the Environmental Protection Act. We had a situation where we had a lot of pollution in the United States, a lot of bodies of water, including right here in downtown Houston. Buffalo Bayou was so badly polluted, there was no wildlife in Buffalo Bayou. And there were a lot of other problems. In Los Angeles, they invented a term called smog because they had smoke from cars and manufacturing and fog coming in off the ocean. The prevailing winds come in from the Pacific Ocean and come easterly through the city of San Francisco. There are mountains behind the city, and it would stop the air right there, and it would trap this bad envelope of air around the city of Los Angeles. And so the city was quite famous for bad air. Denver, Colorado, Pittsburgh, Pennsylvania, other cities that were very well known for having very poor air quality. And again, most American rivers were heavily polluted. In our nation's capital, the river that runs up to the turning basin is from the Chesapeake Bay was famously very, very polluted. It ran around the Jefferson Monument and National Airport in Washington, D.C. So a lot of different places that had significant pollution. In any event, one of the number one contributors to pollution is the automobile. And so around 1972-73, the American manufacturers, Ford, Chevy, and Chrysler, began to experiment with ways to make the cars be less polluting. And these cars were some of the worst cars ever made in the United States. And in fact, it gave a gigantic boost to the major Japanese automakers, particularly Toyota, Honda, Mazda, and at that time Datsun, now Nissan. And so people began to turn to those cars because they were better made, and they already were designed to be energy efficient, didn't need as much pollution control as the larger, heavier American cars. So in any event, because these cars performed so badly, people went to their Congress representatives and said, hey, you know, car is a major investment for most American families, and this is really a bad deal for us. And so to make it clear that the Congress was involved or interested in the problem, they passed Magnuson-Moss, and basically it says, if an automobile is repaired 4 times for the same problem, a new automobile, then it can be brought back to the manufacturer. So it's a pretty interesting deal, but I thought you might find it interesting to know how that came about in the United States. Now, again, watch out for this term as is, and it does mean that there are no warranties. Notice that in addition to telling the buyer that things are being sold as is, if the buyer has examined the goods and there is no implied warranty. Seller demands buyer to examine, a buyer refuses, there is no implied warranty. That's kind of interesting. So you've got it one way or you've got it the other way, but it comes out the same. Now notice these other exclusions. These are the same that we saw in the earlier part of Module 4 that are these other exclusions to our contracts and our written requirements. Course of dealing between the parties, course of performance, usage of trade. So these are, any of these mean you do not have to have your exclusion, you do not have to have a waiver of your implied warranties. So watch out for that also. Now, your manufacturers can limit the remedies for breach of warranty. And in fact, in many cases, a good example of this for you is the click wrap agreement. Many of you aware if you download software to your computer, there's going to be a disclaimer from Microsoft or whoever wrote the software that says you agree that in exchange for buying this software at a reasonable price, that you will not hold Microsoft liable for any damages in excess of the cost of the software. So if you pay $100 for the software, you load it to your computer, it blows up your $700 or $800 computer, doesn't matter. The worst you can get is the $100 that you paid for the software, if they agree to even that. But usually there's quite a bit of warranty disclaimer from software companies. Again, that's known as a click wrap agreement. Now, keep in mind, you've got the right to cure. It may allow the seller to repair or replace non-conforming goods. Sometimes you'll see a disclaimer that says, your limitation here is if you don't like what you bought, the worst that we can end up with is you get your money back, or you can swap the item, but you can't get your money back. Now, watch out for this important term, unconscionability. What we're looking for here is this is largely for consumers, not businesses. And the question is whether the consumer is being treated in an unconscionable manner. Now, the buyer must give notice to the seller that there is a problem, and it generally must be given within a reasonable period of time. So some of the policies behind that, I just mentioned it, seller's right to cure. Seller's a right to go get a new product and say, here, if that one didn't work, here's another product for you. Seller's an opportunity to prepare for negotiation, litigation. Hopefully they're going to settle the case. Provide some psychological protection for sellers. Merchant buyers are bound by a stricter notice requirement. Now, in the past, a breach of warranty historically required privity of contract. In other words, a contract between the parties. In the case of our lawnmower, if you have a defective lawnmower, that you bought it from a merchant who sells lawnmowers, they stand behind the lawnmower. However, it depends on where the situation is. If the item, for instance, causes personal injury, generally speaking, that's going to be an exception to the privity of contract rules. So here are some concepts behind horizontal privity of contract for the purpose of warranties. The warranty extends to any person in the family or household of the buyer. Extend warranties to any natural person who may be reasonably expected to use it. The warranty extends to any person injured by the good. Now, vertical privity, of course, is people in the line of purchase or related companies and so forth. But in looking at this situation, I want to caution you that with regard to written warranties, a lot of times it does require privity of contract to use a warranty. But that can include, for instance, you buy the lawnmower that we're talking about at Walmart or at Home Depot. The manufacturer, say it's Toro lawnmower, Toro is responsible, but also the Home Depot or Lowe's that sold you the unit. And then you have a couple different targets there in terms of trying to get some relief. But if you've just bought it third party down the road, the original manufacturer may say, no, we're not really interested in having our liability extended that far. Again, big exception is personal injury. So watch out for that. Now, in terms of enforcing an automobile warranty, they're saying vertical privity. You've got to have someone in the direct line of command in order to come after them for the warranty on the car. So that's important. Most of us are well aware of that. Now, this is a set of 3 slides that I'd like to point out to you. Remember, one of the things I've talked about as we've gone through the courses up to this point is that periodically these slides have a summary slide or a set of summary slides like this, and that if you're setting up a separate set of super slides to help prepare for your upcoming midterm exam or for the final exam later in the semester, that you may want to pull some of these slides that help you to consolidate and review your information in a more structured format. So this is a very useful chart. It runs, again, for 3 slides. So the conditions of the goods giving rise to liability: not merchantable, not fit for its ordinary purpose. That hits under the warranty merchantability. Strict tort liability: defective condition, unreasonably dangerous. Character of the defendant: must be a seller as a merchant with respect to goods of that kind. Tort liability: must be a seller engaged in the business of selling such a product. So pretty similar there. Reliance is the next issue. Then notice. Under tort liability, it says consumer is not required to give notice within a reasonable period of time. Now, watch out for this, because if the injured consumer waits too long, they may run the state statute. And in Texas, that's 2 years for a routine tort responsibility. Now, this is a difficult one. It says buyer may recover consequential damages from seller's breach, including injury to person or property. Well, I guess you're seeing that in the Johnson & Johnson baby powder cases that are on TV and the Roundup lawsuit cases. Now, warranty merchantability, who's protected, and generally speaking, it may include third persons. Under tort liability, ultimate user or the consumer. And then protected injuries, physical harm to ultimate user, consumer, and so forth. Statute of limitations, 4 years from tender of delivery. That's generally limited by the sale of the item. In most cases, it limits it to the state law or puts in even a shorter limit than that. And then in the corner of the slide, 3 of 3 here, state law varies from 1 to 3 years from injury. In Texas, defamation has a 1-year statute of limitations. Other torts, a 2-year statute of limitations. And again, you may want to clipboard these 3 slides. Now, we also want to look at global sales law. Warranty provisions are not easy to collect internationally. And you may say, well, gee, I bought that Sony TV set and I was able to get warranty service. That is correct. We have had a lot of support in certain areas. And so certain foreign companies open U.S. Headquarters, make themselves subject to U.S. law in order to exploit the healthy U.S. Consumer market. So there's a little bit of a play in these things, in other words, from the way to look at them. And so the CISG does capture the essence of the warranty and merchantability, fitness for a particular purpose under the code. Trade usage is respected with regard to warranties. Now, before we close out Chapter 23, I want to give everybody a chance to ask any questions that they've had as we've gone through this chapter. All right, well, you're a quiet bunch tonight. Okay, I'm going to assume you know all of this material. I don't consider this a particularly difficult chapter, but there is some information that you will need to keep in mind when you prepare for the final.
Yes, in the topic of warranty of titles, I don't know if you've seen some companies out there, websites announcing deeds for the moonland.
That's fascinating. I think that somebody claims something. I know that for a while there, one of the things they would do on radio, I don't know that I ever saw a television ad, is that you can get a certificate that names a star after somebody. And I think that's the same kind of thing. It's so fanciful that it's not something that can be prosecuted. So I don't know if there's any, I've never researched the subject of whether there's anything legally enforceable there. I suspect not, because the 2 major powers before China rose to be a 3rd power was the United States and the former USSR. And they agreed that space would be non-political. And so I would think that that would apply to the moon. Nobody owns the moon. And so I don't know that those deeds would be enforceable. Fanciful and interesting, but probably not enforceable. Great question.